Good evening to all the participants of the JCJ 2022 main examination. Karibu sana, welcome to my class. Yes. Could you see my screen? Anyone? Yes. What is there on the screen? Participants. There is a gavel, there is a sound peg, and there is a book, and as well as there is a balance also. And I already notified that today that I am going to deal the class which is section 14. Section 14 of the Specific Relief Act. Kotla Mohan, welcome to my class. Are you hearing me? Kotla Mohan, are you hearing me? Unmute and give me the answer. Kotla Mohan, are you hearing me? Unmute and give me the answer. Okay, doesn't matter. At least you could hear me. So now the today class is I am going to deal with the section 14 of the Specific Relief Act. It's a significance and application. And actually that excerpts, and I have taken the note from the Harsh Gupta from the School of Law, that is a Jamia Hamdar, the HILSR. So let us see the catastrophe with him that I am dealing it. So if you happen to see the significance of the section 14 of the Specific Relief Act, Kotla Mohan, are you hearing me? Unmute and say yes. Could you read it? What is there in the introduction, which I highlighted here, so that I could know that you are hearing me and I am hearing you, and both traveling in the same boat. Yes, read. Okay, I think you are a newcomer, it seems. That's why you could not make it out. Okay, the Specific Relief Act 1963 is related to the Indian Contract Act 1872 because it is nothing but a contract. And hence we can say the genus is Indian Contract Act and the species is the Specific Relief Act. So where the later defines the right and duties party to the contract and the former provides for the remedies available to the parties to the contract. So now former provides means which one is Indian Contract Act? And no, it is a former means here the Specific Relief Act. Later means Indian Contract Act. When you see that parties to the contract and the former provides for the remedies. If you make the breach of a contract, what are the remedies available to the parties to the contract? And the Specific Relief Act provides for the exact fulfillment of the obligations or the specific performance of the contract. In some places, remedy is not the point. Contract should be performed. And in that case, we can enforce the specific performance of the contract. Now the question comes to our mind is, what relief for what? Suppose if a breach of a contract is there, and he wants to sell the house. Okay, let us presume it. But the house is collapsed because of the earthquake. Now the subject matter is no more over there. Then how could you ask for the specific performance? Could you ask him to construct another house and sell the house? Answer is no. Because at the time we can say frustration of the contract we already seen. So in a contract, there are many clauses, and these clauses are contractual obligations that need to be fulfilled by the parties to the contract. So the parties to the contract, they will make the terms and conditions. With that, they will bind the contract, and there are obligations are there, and that should be fulfilled by one party to the other party. If any party to the contract breaches their contractual obligation, at that time, towards another party or parties, then compensation has to be provided for the damages resulting from the breach of a contract. So one of the remedy for the breach of contract is, what is? One of the remedy for the breach of contract is, yes, damages. So if the party to the contract breaches for the contract obligations toward another party or parties, the compensation has to be provided for the damage resulting from the breach of contract. wherever or whenever there is a breach of a contract by one party in the contract, the remedy is available for the another party in the contract. Generally, yes. Now, a party to the contract can be remedied in two ways. How? Let us see. By providing the pecuniary compensation, or when the pecuniary compensation is not adequate, in that case, specific relief will be provided by way of the specific performance. And monies will not compensate it for the breach. At that instance, the party will ask for the specific performance of the contract, provided the subject matter should be in existence. Like I told you, by earthquake, the house is collapsed. At that time, we cannot force the party for the specific performance because it comes under the participants. It comes under the frustration of the contract. Yes, a specific performance is a discretionary remedy that the court provides to the affected party. So it is not a right to the other aggrieved party. It is the discretion of the party and governed by the Specific Relief Act of 1963. Specific performance refers to the duty imposed by the court on a defendant to perform what he promised and is obligated to perform in accordance with the terms of the contract he entered into with the plaintiff. However, in this article, the author has laid down the emphasis on Section 14 of the Specific Relief Act 1963 and its applicability. Because Section 14 is a very important section of the Specific Relief Act. Now let us see the contracts that cannot be enforced specifically. Which contract cannot be enforced specifically, which is enumerated below. As a result of the provision of the Section 14, the following contracts cannot be relief of specific performance. In the case of adequate compensation, if the adequate compensation would be there, as per the Section 14, subsection 1, clause A, the court will not order specific performance in case a party seeking compensation is able to obtain reasonable compensation, and that is a reasonable compensation, and the court feels it. In the case of Meenakshi Sundara Mudaliyar Ratnasamy Pillai, that is the case law, and there it was held that ordinary loan contracts, whether with or without security, can't be specifically enforced, but where a loan has already been advanced and security has been agreed to, that can be enforced specifically. So it was said that ordinary loan contracts, whether with or without the security, it cannot specifically enforce. But where a loan has already been advanced, already given, and a security has been agreed to, then can be enforced specifically. So when the surety would be there, agreement would be there, money is paid over there, when there is a breach of a contract, at that time you can ask for the specific performance. So it depends upon the terms and conditions, and it is the discretion of the court whether such a contract would be performed or not. According to Chitty's contract, who is Chitty? He is a famous author in the contract. Like we do have in the contract, no, I think it is evidence. Woodruff Wolf and Amir Ali. Yeah. So, according to Chitty's contract, the specific performance of a contract to build can be decreed if, number 1, the work is precisely defined. Number 2, damages will not adequately compensate the plaintiff. Number 3, the defendant is in the position of the land on which the work is to be done, so that the plaintiff cannot get the work done by another builder. So, in these circumstances, according to Chitty's contract, it will be specific performance of contract to build can be decreed. So, number 1, number 2, number 3, just now I narrated. Participants, are you hearing me? Give the answer, please. Clauses of uncertain character. This is another clause. A lawsuit was filed seeking a specific performance of the lease renewal agreement. In the case of the Shanti Prasad Devi versus Shankar Mahato, is the 2005 case law. It was further found that the option of renewal had been exercised against the renewal clause. It is the renewal clause has existed. Again, the renewal clause there. The clause required the terms to be fixed and renewal conditions and period can be discussed and the mutual agreement, though the mukhyas or panchas of the village. The agreement did not name any such persons. Legal notice of the renewal was served by the lessee without first obtaining the mutual consent. The lessee did not receive the relief of renewal. Whenever the renewal would be there for the contract, it will be the mutual agreement between the two parties on certain conditions. The conditions may be there, the lease period will be more, or the rent will be more, or some other perks should be given over there. Some conditions will be laid on there. Then if it is agreed, then it will be renewed. Either the lease is concerned or the house rental is concerned. It depends upon the period of contract. So here the lessee did not receive relief in the renewal. No. The renewal is mutual understanding between the two parties. Like that. For instance, I am working in the south, that is the St. Augustine University for Tanzania, Mwanza, Tanzania. And the mutual agreement, the contract will be renewed. That clause is there. Suppose if I want to renew the contract, then the employee should be also in the same condition, mutual agreement that he should have to say, okay, we will give the contract. If it is not there, if such a thing is not there, then the mutual agreement is not there, then the contract cannot be renewed. So that is actually the thing where the mutual consent should be there. In the case of the Perceps D. Mark India Private Limited versus Zahir Khan 2006 case law, it was held that the specific performance of a contract for a personal or confidential and fiduciary services that depends upon the mutual trust, faith, and confidence is barred under the section 14A, clause A, clause B, clause C, clause D. How it can be? That means specific performance of a contract for personal or confidential and fiduciary services. These are all depends upon the mutual trust, faith, and confidence is barred under the section 14A, B, C, D. If the mutual consent would be there on the good faith, then the contract can be renewed. If the faith would not be there, then there is no such a renewal. We cannot insist for the renewal. So that is specifically mentioned in the section 14, clause A, clause B, clause C, and clause D. Let us see the contract that are determinable in their terms. Section 14, subsection 1, clause C. A contract that is in its nature determinable does not require a specific performance. I repeat. Ossia, can you read this one? Ossia, are you there?
Yes, sir.
Can you read that
That
one?
is in its nature determinable does not require specific performance.
Yes. A contract in its nature determinable does not require a specific performance. Let us see the word. This point is more than sufficiently explained by the illustration appearing under the corresponding provision of the Repealed Specific Relief Act 1877. Let me see the example. A and B agreed to become partners in a particular business. When the partnership will be formed, how's here? When the partnership will be formed by the mutual agreement between the parties. Am I right?
Yes, sir.
They cannot specify how long the partnership will last. The contract cannot be specifically performed, since A and B might dissolve the partnership immediately if it were so performed. Partnership, either they can fix the duration or the faith understanding between the parties are there, it will be continued. If it is such a thing will not be there, then it can be breached partnership. In the case of the Lewis versus Bond, it was held that if the contract is irrevocable at the other party's option, no order for specific performance is likely to be passed. When you are given a contract, in the contract itself is the other party can revoke the contract. At that instance, you cannot ask for the specific performance. Is it clear?
Yes, sir.
This category includes revocable leases. In the case of Liver versus Kofler, it was held that a tenancy from year to year, determinable by either the party of half-year notice to the quit, is however specifically enforceable. Suppose if a notice will be given, the term is there, half-yearly, at the time, you have to vacate it, quit it, and it is specifically enforceable. Because it's the tenancy. Generally, the house tenancy per how much period? Sir, 99 years. Tell me.
11 months, sir.
Only 11 months. And 1 month notice will be given. If both the parties mutually agree together, it will be renewed by keeping the 5% extra to the earlier rent. Am I right? Or 10%.
Is it must, sir?
Yes.
Is it compulsory, sir? Increasement of rent?
Definitely that provision is there. At least 1% to 5% or 5% to 10%. Each year.
Okay, sir.
If such a condition would not be there, agreement between the two parties and the good faith and good people are there, at that instance, okay, they will say, let it be continued. The same rent. Is it clear?
Yes, sir.
So, if the tenancy from year to year at the time, when the notice is given, yes, it can be enforceable. Employment contracts are not specifically enforceable. An individual selected for a position was not permitted to hold it. In the case of Nandganj Sihori Sugar Company Limited versus Badrinath Dikshit, the court observed, court don't ordinarily enforce the performance of the contract of a personal character, such a character of employment. The remedy is to sue for the damages. Specific performance is entirely discretionary and must be refused when it is not warranted by the ends of justice. So, employment contracts, it can be revoked provided there are conditions are there if you violate those conditions. And that is the discretion of the court for the re-employment. It is not your right when you are fundamentally at fault. Such a relief can only be granted on the sound legal grounds. Yes, re-employment will be given to you only on sound legal grounds. In the absence of any mandatory statutory requirements, I say absence of, court don't ordinarily force the employer to hire or retain the employee not required by them. It is the discretion of the employer. Hire and fire. Am I right?
Yes, sir.
Say yes or no.
Pass on, sir.
I could not hear your voice.
Pass on, sir.
It is the discretion of the employer to hire and fire in private
Yes, sir.
jobs. But in government jobs, it's not so easy. Because there are a lot of rules and regulations are there. And one should have to follow it. Okay, at the moment they will say suspend for a while. But when the suspend would be there, half of the salary would be given till the disciplinary committee make it clear. or the court makes clear, because there are many places the labor court have given the re-employment with the arrears. Am I right?
Yes, sir.
Rejoining with the arrears. Yes, because injustice is done to them because of the partiality or because of the vengeance or many other factors are there. And that made him to get the re-employment and rejoin with the arrears. Said an exception to exist to this rule, such a public servant dismissed for the violating the Article 311 of the Constitution of India, reinstatement of a dismissed worker under the industrial law, a statutory body acting in the breach of the statutory obligation, etc. This case falls outside the exceptions, especially for the public employment. It is not so easy to terminate the services, even a peon or a chaprasi or a attendant. Is it clear?
Yes, sir.
Therefore, the plaintiff sued for mandatory injunction was rightly dismissed by the trial court, wrongly decreed by the first appellate court and the high court. Unless until it comes under the exceptions, then only the public servant services will be removed. You know, the conductors, earlier they used to dismiss it several times, suspended for 1 year, 2 years. Of course, after the labor court, again they will reinstituted. Of course, condition is there, continuation of the employment or a fresh employment. That depends upon the court discretion how rejoining would be there. If it is a genuine case, then all the services will be counted, plus increments will be given, and he will get with the arrears, even though he did not work. Am I right?
Yes, sir.
In the case of Indian Oil Corporation Limited versus Amritsar Gas Service 1990, it was held that distributorships are determinable nature. An order could not be entered for their restoration. Of course, this is a distributorships. So, in case of the Vidya Securities Limited versus Comfort Living Hotels Private Limited 2002, it was held that the interim injunction that would restrain the termination of the plaintiff's restaurant contract could not be granted because it is a private contract. Am I right? Do you have the government restaurants now? Do you have the government restaurants now?
No, sir.
Even everything is now privatized. There is the question of government restaurants. Forget about now. Forget about the government job. Am I right? Only
Government
except,
job.
Sir.
Yes.
only except teachers, police department, and military.
Yes, sir. How are you, sir?
Yes, welcome. So now we got some live voice here. So now in the case of Bharat Petroleum Corporation Limited versus Khyber Transport Private Limited 2011 case law, a license to run a petrol pump was terminated. The license was granted under the revocable agreement. The court said that the only remedy for the license was to sue for damages, not for the specific performance. Why the license should not be given to us? Not to enforce the agreement. The suit was filed was liable to be denied because license it will be given on the discretion of him. They will show any reason and they will not renew the license. Am I right?
Yes.
Could you say that I fulfilled all the conditions? Why the license should not be granted to me? Answer is, it is the discretion of the petroleum company limited, unless until there would be agreement. For the 10 years mutual, even agreement would there. There is a. I don't think when the agreement is there, they deny it.
No, even if there is agreement.
Is it?
even if there's agreement for 10 years, even if they get a complaint stating that the
Adulterated.
petrol bunk owner is doing some malpractices,
Okay.
then also his license will be suspended, or
Okay.
else it will not be
Okay.
renewal next year.
Okay. Even though there is an agreement.
Yes, because
Because he
it should not
violated the
affect
terms
public
and
and
conditions.
it should not affect the public and the damage, and should not affect the damage of the company's name.
Reputation of the company.
Yes.
So thank you very much, SR Venunath. Even though there is an agreement, if they violate it, it cannot be renewed.
Yes, आजकल आप देखते हैं पेट्रोल बंक में 1 लीटर बोल के they don't give 1 लीटर नहीं देते वो लोग, they give less. They add petrol में they add kerosene and sell. ये सब
Now
करते
kerosene is not will be seen at all.
हैं.
I don't know how the people are even cooking, because at the time you should have the kerosene, pumps, stoves, and where we can pump it and will
But these people
cook the food.
they still get from this public distribution system, na?
At the fair price shop.
Yes.
Now they are making it. It is not a white kerosene. It will be a lightish
Green.
blue.
Bluish green color it will be nowadays.
Because if you mix in the petrol, it will be easily seen.
But they will not mix so much. इसका क्वांटिटी अलग रहता है ना आजकल के बहुत सारे केमिकल्स आ गए बहुत सारे केमिकल्स आ गए आजकल.
Okay. Now let us see the class D of the section 14, subsection 1 says that court cannot enforce a contract in cases where the order involves the performance of the continuous duty under the supervision of a third party. For this reason, it was observed in the case of Ryan versus Mutual Town Westminster Chambers Association case law. The court have refused specifically to enforce an undertaking by the lessor of services flat to have a porters constantly in attendance. A tenant's undertaking to cultivate a farm in a particular manner, or a railway road company's obligation to operate the signals and provide powers, or a contract for the operation of an airfield, and the obligation of the ship owner to deliver the goods in installments. So in certain places, you cannot ask for the specific performance. See, you know the level crossing, railway level crossing.
Yes.
Is it mandatory to keep a attendant at the level crossing?
Yes. Unless there's a discretion for that. Unless a level crossing is which has a gate. But
Which
nowadays,
has the gate, attendant should be there.
yes. But where
And
there
we
is
have
no
to
gate,
lock it when the train comes.
लेकिन
Unlock
आजकल
it
क्या
when
है?
train passes away.
But आजकल कैसा है?
उसके नीचे से चले जाते हैं.
नहीं वो नहीं. Railway has developed the technology in such a way.
Automatically it will be stopped.
Automatic वो जब तक वो गेट गिरेगा नहीं आपको सिग्नल नहीं मिलेगा. जब गेट गिरेगा आपको सिग्नल मिल जाएगा.
That is
Automatic.
true. That is true. So, unless until he will keep the key, then only the signal will come. Otherwise, the signal will not come. And now the system is in rural, very remote corners, there is a unattended level crossing is there. When unattended level crossing, they keep the caution board.
Yes.
And the caution board says, look before you are crossing.
Yes. That is reasonable care. You should have reasonable care.
And they will be written in the local language.
Local and Hindi.
Yeah, that is just the national language. And that unattended, there would be there.
Yes.
So, for such a thing, we cannot ask them to specific performance. Because of a third party would be employed over there, it is the discretion of them. Whether it is a too much heavy rush would be there, naturally they will keep the flyover.
Yes.
Or tunnel, whichever is feasible to them, and allow their packet to do so. So in the case of Zaina BV versus MK Govinda Swamy 1965 case law, it was held that an agreement between a tenant and a landlord, under which the landlord promised him that he would be provided with certain premises when the tenant vacated the site for the reconstruction purposes, was held to be contractual. Suppose the landlord makes it. Okay, I will give you a better house than this, and he vacated it. Can you enforce the landlord to
Yes,
enforce
yes,
such a contract?
yes. There's a provision in this thing. There's a provision in law.
Is it in the written form or is it in the oral form?
It's in the law only.
If the orally also they have given, and he can ask for the specific performance.
Yeah. Example: if I'm a tenant
Yes.
in a particular flat or a
Okay.
home, and the owner comes and tell me I'm doing renovation of this flat
Yes.
or this home. Once this get renovated, I will give it to you back.
The same rent.
The same rent, and it'll say I will renovate the flat and I'll give it to you.
Okay.
But after renovating, he cannot go back. He
Okay.
has to give me that flat again on rent only.
But what about the condition?
But whatever
Tenancy rent.
tenancy, no, that's a different thing. That's a different thing. Whether the rent will be increased or decreased, or it will be same, that's a different thing. But he has to give the flat unless the tenant refuses saying that.
So naturally, whenever the renovation is there, the rent will be increased.
Yes, yes, that will increase. That is subject to condition. But normally, if you say कि मैं आपको घर देता हूँ, मैं renovate कर, because most of the owners what they do, they tell lies. अरे हम घर renovate कर रहे हैं, हम इसके लिए चाहिए, हम आपको बाद renovate होने का देते. No one gives. वो अलग बात है. But if someone challenges, then you can.
That's why the people say,
unless
let the house would be locked, but should not be given to the tenancy.
Yes,
Because
unless until
it is easy to give the tenancy, very hard to vacate him.
vacate them. Yes, yes.
So specifically, if the borrower does not plan to repay the loan immediately, an agreement to provide a security to execute a mortgage against the loan is binding. When you want to get the loan, the bank will not give 3/4 loan to the cost of the building. They will give only 50% at the most for the value of it. In cases where the lender has advanced only part of the loan, if he is willing to advance the remaining part of the loan as well, he can claim specific relief. If it is proved, just now we made it. If he says that after renovation we are going to give you, that means you should supposed to give. So specific performance can be applied over there. The agreement to take up and pay for the debentures of a company is also specifically enforceable. Venunath,
Yes, sir.
these debentures, shares, if once they promise, do they specifically perform?
No, shares, that completely depends on the market.
Okay, okay.
Debenture is like you are giving a loan to the bank, to the company.
Okay.
Debenture. So if the company takes money from the public in the form of debenture,
Okay.
the company in the initial stage only, it declares that we will be giving 10% or 13%, 12% interest.
Okay. Is it per month or per year? Is per year.
Whatever 12% per annum they say.
Okay.
So that they have to give. That is compulsory. But shares, it's all subject to market risk.
Suppose a share value can be increased or can be decreased also.
That's purely on the market.
It's like a gambling.
Yes, yes. If I buy a share today of 10 rupees, tomorrow the price can increase and become 100 rupees, or the price can even become 1 rupee also. I cannot go and question the company why the share value has come down to 1 rupee.
But still the people will buy the shares.
वो secondary है, it's वो gambling जैसे है, आपको खरीद लो.
What about the mutual funds?
Mutual funds all are subject to market risk.
Okay. So once a debenture are there, one should have to make specifically, even though the company runs into losses.
Yes, debenture is something different. Debenture is you have to give that amount.
Okay. That means a specific performance can be done.
It is like debenture is what you are taking loan from the public.
Okay.
It has nothing to do. Shares kya hai? When there is a profit in the company, the share value increases. One.
Okay.
When there are good orders internationally or locally, the share value increases.
Okay.
लेकिन शेयर वैल्यू इंक्रीज हुआ बोल के you don't question the company ना शेयर वैल्यू कैसे इंक्रीज हुआ you take money and keep quiet.
Okay. And we
Their
can sell
value
sell shares at the time when the value is
yes
more.
yes you can sell it, no problem. But the same way, when you can't question the company when the share value is high, you cannot question the same company when the share value is less.
Low. Okay.
Yes, but however, when it comes to debenture is like you are taking money from the public on in the term of loan. It is called
Okay.
debentures. You issue a certificate.
Okay.
Shares also you'll get in certificate only, but it's a risk business.
Okay.
Yeah, value can increase, decrease, anything, it's fluctuation. But debenture, it's not fluctuation. If the company take 1,000 rupees from me and says I will give you 10% interest per annum, so it's understood. 1,000 रुपए के ऊपर 10% मेरे को कितना मिलने वाला है एक साल के बाद.
Okay. So, in addition to the agreement to execute the formal deeds of partnership, the agreement to buy partners' share in the business are also specifically enforceable. So, partner shares is specifically enforceable.
Yes. Because people invest funds. If two partners are there,
Okay.
they invest money equally or proportionately.
Achha. Yeah, now the time is up. At any time, it will be stopped. So, up to that extent, if you want to ask anything, you can ask me, and I will be back. My classes will be continued at least up to the 17, because there is an international conference is there in Alwar. Here I am showing emerging trends in the, of course, this is my topic, emerging trends in the legal tech landscape development in India. So that is it is a topic which you want to make it out, and I prepared this one. There are 18 speakers are there. I don't know whether you could see it or not. So 19 to 20, it is a blended mode. Means online also we can make it out and offline also we can make it out. So most of the people online, only the few people from India is physically they will be present, but most of the people are online. And the Sunrise University, Alwar, Rajasthan in India, and they are going to conduct on 20th October 2022. Of course, platform they will inform me from 10 a.m. to up to 6 p.m. And the speaker in IMCR, that is the Innovative International Multidiscipline Conference in Present Research. So you can take any theme, any subject. If anybody wants to contribute it, you can contribute it. And for the details, you can ask me, and they will also post. That will be published again if the selected paper on the service basis, and that will be counted for your promotion or the prerequisite to get the PhD also. So
अच्छा
better
सर, ये
try
जो
to avoid
सनराइज
it.
यूनिवर्सिटी है,
Yes, sir.
this Sunrise University, is it recognized one or it is?
You can type in the Google search engine and you can give me the what is the authenticity, because I was there for the 2 days. Yes.
No, this is recognized by UGC.
Yes. Everything is there.
It's a private university.
It is a private, like the deemed university, and it is there. Alwar, the Tiger Gate of Rajasthan. Alwar is called Tiger Gate of Rajasthan, and it is very adjacent to the Delhi suburban, and it
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मागे। गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
We live in a world full